Chumba chetu cha matangazo. Ili ni shina la upeo, mtazamaji. Kesi ya kusikilizwa kubanduliwa kwa aliyekuwa gavana wa Nairobi Mike Sonko inaendelea katika mahakama ya Milimani. Kesi hiyo mbele ya jopo la majaji watatu inaamuliwa baada ya Sonko kuwasilisha kesi mahakamani kulalamikia kubanduliwa kwake. Kwa sasa mtazamaji, tutavuka moja kwa moja hadi katika mahakama ya Milimani tusikilize kile ambacho kinaendelea.
As deputy governor, according to him, the withdrawal letter was sufficient and he did not breach any law as there was no procedure set out in either the County Government Act or the Supreme Court's advisory opinion in Speaker County Assembly of Embu for withdrawing a nomination that was yet to be approved by the County Assembly. Honorable Sonko additionally submitted that Section 51 of the Interpretation of General Provisions Act Cap 2 empowered him to revoke the nomination. He therefore urged us to find that upon the withdrawal of the nomination, the County Assembly had no jurisdiction to vet or approve the appointment of Hon Kananu. In a rejoinder, Hon Kananu submitted that the purported withdrawal of her nomination was ill-motivated, an afterthought, and had no legal effect. According to her, no reasons were given for the alleged withdrawal and that the leave of the County Assembly was not sought. The County Assembly's position was that the withdrawal of nomination letter was brought to its attention as The County Assembly's position was that the withdrawal of the nomination letter was not brought to its attention as provided for under its standing orders. The second respondent submitted that as averred by the Speaker of the County Assembly, the withdrawal letter is a forgery, which is the subject of police investigations. The Speaker of the County Assembly submitted that there was no letter from Honorable Sonko withdrawing the nomination of Hon Kananu for the position of Deputy Governor. He maintained that he only became aware of the alleged withdrawal letter on 7th January 2021 when Hon Sonko filed a cross petition in the Peter Odhiambo Agoro case. He added that the stamp on the letter did not have any signature indicating the person who received it, as is the procedure, and neither does the letter exist in the register of documents and letters kept in his office. The 7th and 8th interested parties denied the allegation by Hon Sonko that they were involved in the revocation of the nomination of Hon Kananu. According to them, there was no telephone conversation between them and Hon Sonko over the issue of the position of the Deputy Governor of Nairobi City County. They urged the court not to attribute any probative value to the alleged telephone conversation and, by extension, the letter allegedly revoking the nomination. We have perused Honorable Sonko's letter dated 6th January 2020 nominating Honorable Kananu as the Deputy Governor. We note that the letter is addressed to Honorable Beatrice Elachi, the then Speaker of Nairobi City County Assembly, and we have given the entire extract of the letter in this judgment. The court record shows that on 3rd December 2020, the County Assembly passed a resolution to impeach Honorable Sonko. Shortly thereafter, Hon Sonko on 7th December 2020 wrote a letter allegedly withdrawing the nomination of Hon Kananu. The contents of the letter are also in this judgment. So, as can be seen from the nomination letter dated 6th January 2020, the gist of the appointment was that Honorable Sonko was facing criminal charges and had been barred from accessing his office. For this reason, he did not want the operations of the county to be affected by his absence from office. Hon Sonko states that he withdrew the nomination because the Agoro case had taken too long to be resolved. According to Hon Sonko, before the Supreme Court advisory opinion in the County Assembly of Embu, there was a lacuna in law relating to the filling of vacancy in the office of Deputy Governor. We note that whereas the advisory opinion was rendered on 9th March 2018, it took Honorable Sonko close to 2 years to act on the advisory opinion. From his nomination letter, we can deduce that he only acted after he had been barred from office upon being charged before the Anti-Corruption Court. From the above narration of the sequence of events preceding the revocation of the nomination, it is our finding that the conduct of Hon Sonko is that of a person who was not in a hurry to fill the vacancy in the office of the Deputy Governor. The delay in nominating a person to fill the vacancy, despite the existence of the Supreme Court advisory opinion, when considered alongside Honorable Sonko's earlier botched attempt to appoint Miguna, who he knew very well was not a member of his political party, lends credence to Hon Kananu's averment that he was not sincere in nominating her or having a deputy governor at all for that matter. The fact that Hon Sonko wanted to take over the Agoro case, which was challenging the nomination of Hon Kananu, further confirms Hon Kananu's averment that her nomination and subsequent attempted revocation was tainted with malice and ill will. His actions in respect to the Agoro case support Hon Kananu's claim that he was the real sponsor of the move to stop her vetting and approval by the County Assembly. The inconsistency of Hon Sonko as to the reasons for the withdrawal of the nomination of Hon Kananu clearly emerges when one considers his averment before this court that it was the 7th interested party who requested him to nominate the 8th interested party in place of Hon Kananu. This is an entirely new reason that is not found in his withdrawal letter. We are perplexed and find it hard to believe that a state officer in the high office of a governor can have the temerity to state under oath that he took telephone instructions from ordinary citizens in the execution of his constitutional mandate. Without saying more on this point, it is apparent that the 7th and 8th interested parties' position that they did not contact Hon Sonko in respect to the revocation of the nomination of Hon Kananu is exceedingly likely to be true. Our position is fortified by the evidence from the telephone service provider that there was no communication between Hon Sonko's telephone number and that of the 7th interested party. Another reason why Hon Sonko could not legally revoke the nomination of Kananu is found in Section 18 of the Elections Act, which stipulates as follows, and I will quote that section: change of deputy county governor nominee candidate. A county governor candidate or a political party shall not at any time change the person nominated as a deputy county governor candidate after the nomination of that person has been received by the Commission, provided that in the event of death, resignation, or incapacity of the nominated candidate or of the violation of the Electoral Code of Conduct by the nominated candidate, the political party may substitute its candidate before the date of presentation of nomination papers to the Commission. I end the quote. In the instant case, it is not disputed that the nomination of Hon Kananu had been received by the IEBC and that the appointed returning officer had issued her with a certificate of nomination on 10th February 2020. There is no evidence that any of the events contemplated in the proviso to Section 18 of the Election Act had occurred in her case. It is therefore our finding that the attempt to withdraw the nomination was unlawful and without basis. Hon Sonko relied on Section 51 of the Interpretation and General Provisions Act Cap 2 as authorizing him to withdraw the nomination. We have highlighted the provisions of that section in this judgment. We find that the section is not applicable since the Constitution under Article 182 provides for the procedure for filling a vacancy in the office of the Deputy Governor. In any event, were Section 51 to be applicable in the circumstances of this case, the Governor is only a nominating authority and not the approving authority. We note that under Section 51(2), certain appointments that are subject to the approval of other bodies and any action regarding such appointments can only be taken with the approval or consent of the other bodies. We find that Hon Sonko could not therefore unilaterally withdraw the nomination without the approval or consent of the County Assembly. agreeing with Sonko that he could withdraw the nomination without reference to the county assembly would violate the principle of separation of powers. So we are also in agreement with the decision made in petition E019 of 2021 by Mrima J on 9th February 2021, when the judge expressed himself as follows, and I quote, "The County Assembly of Nairobi City County is governed by the Constitution, the law, and its standing orders. Once a matter is received by the County Assembly, it can only be dealt within the said constitutional and legal confines. Unless the contrary is proved, such a matter becomes a property, so to say, of the County Assembly." End of quote. We additionally observe that as at the time the alleged withdrawal of nomination, the conservatory orders issued in the Agoro case had not been vacated. The attempt by Sonko to withdraw the nomination was an indirect way of interfering with the ongoing court process. From our foregoing observations, it is not difficult to agree with the Speaker's averment that the letter allegedly withdrawing the nomination was not delivered to his office for onward transmission to the County Assembly. In this regard, there is therefore merit in the Speaker's further deposition that he only became aware of the letter through Sonko's cross petition in the Agoro case. In a nutshell, we are not persuaded that the nomination of Kananu was withdrawn as has been alleged. So turning to the effect of impeachment of Sonko on the nomination of Kananu, the first petitioner submitted that upon the removal of Sonko from office, the opportunity for the County Assembly to vet and approve Kananu for appointment as Deputy Governor was overtaken by events and irrevocably extinguished. The 8th and 9th petitioners argued that Kananu's nomination as Deputy Governor was dependent on Sonko's continued stay in office, and opined that since both seats were vacant, they would both be filled through a by-election. On his part, the 10th petitioner contended that all the actions and processes initiated by Sonko that were incomplete as at the time of his impeachment lapsed. Sonko submitted that the moment he was impeached, all his uncompleted decisions and actions lapsed. In a rejoinder, the Speaker stated that the impeachment of Sonko did not affect the pending vetting of Kananu, as her name had already been submitted to the County Assembly prior to the impeachment. According to him, there is no legal provision that a nomination pending approval by the County Assembly lapses when the Governor is removed from office. We have considered the provisions of Article 182 of the Constitution and Article 181 of the Constitution provides for the removal of governor through impeachment. Section 33 of the County Governments Act provides for the removal procedure. So from the foregoing provisions, it is clear that the law foresaw a situation where a governor could be removed or be unable to discharge the functions of his office. In all these situations, the end result would be that the governor would not be discharging his duties. It would therefore be absurd to erase all the incomplete actions and decisions that were lawfully undertaken by the governor, that were being undertaken by the governor at the time of his impeachment. Needless to say, the position of a governor is a public office for which there must be continuity, such that the exit of a holder of such an office cannot sound a death knell on all his actions, finished or unfinished. We do appreciate that as submitted by Counsel for the County Assembly, the circumstances of this case are unique in that at the time of the impeachment of Sonko, there was already an ongoing process for the appointment of a Deputy Governor, which was completed after the Speaker had assumed the office of the Governor in an acting capacity. This is not a scenario that was even envisaged by the Supreme Court when it rendered its advisory opinion in Speaker County Assembly of Embu. We are therefore called upon to interpret the Constitution so as to fill in any lacuna that may exist. In this regard, we've referred to the case of Mugambi, Manyara, and another versus Attorney General and 5 others. We also found guidance in the matter of the Speaker of the Senate and another. We observe that before his impeachment, Hon Sonko had voluntarily nominated Honorable Kananu as the Deputy Governor. The County Assembly picked up the nomination and had commenced the vetting process before the court issued conservatory orders to stop the vetting in the Agoro case. As we have already noted in this judgment, the withdrawal of Hon Kananu's nomination was done after the resolution by the County Assembly to impeach Hon Sonko. We observe that even after his impeachment by the Senate, and as late as 7th January 2021, when Justice Omudi allowed the withdrawal of the Agoro case, Hon Sonko still felt that he could pursue the issue of nomination by filing a cross petition. This confirms that he knew that the nomination did not die with his impeachment. We take judicial notice of the fact that there are counties where elected governors have exited office through death or impeachment, and that at no time did the actions initiated by them lapse merely because they had left office. For this reason, we find that it is not far-fetched that an elected deputy governor can become a governor and nominate an unelected governor. Sorry, I'll take that again. For this reason, we find that it is not far-fetched that an elected deputy governor can become a governor and nominate an elected deputy governor, who may eventually assume the office of the governor and nominate an unelected deputy governor. For instance, had Hon Kananu, who was not elected, been vetted and approved when her name was submitted to the County Assembly in January 2020, she would have assumed the office of governor upon impeachment of Hon Sonko and gone ahead to appoint an unelected deputy governor. This would mean that the Nairobi City County would have been governed by an unelected leadership. In our scheme of things, such a situation cannot be said to be a violation of political rights under Article 38 of the Constitution. It is our considered view that upon nominating Hon Kananu and after the County Assembly received the nomination, Hon Sonko's role in regard to the process ended, and that were it not for the court order in the Agoro case, the process would long have been concluded. The impeachment of Hon Sonko cannot have the draconian effect of undoing or terminating the process that was ongoing. We therefore find no error in the action of the County Assembly to conclude the process of vetting after the impeachment of Hon Sonko and the subsequent withdrawal of the Agoro case. Turning to the issue of public participation in the appointment of Hon Kananu, Hon Sonko took the position that Hon Kananu's appointment was devoid of public participation, thereby violating Section 6, Subsection 2 of the Public Appointments County Assemblies Approval Act, Articles 10, 23 of the Constitution. He specifically averred that the public was not given 7 days notice of the impending vetting, and neither was the vetting advertised in a daily newspaper with national circulation, nor was the vetting done publicly. The 10th interested parties case was that Hon Kananu was not vetted at all, but added that no public participation was carried out prior to the vetting. In response, Hon Kananu submitted that the public was invited to submit their views on her suitability through advertisements in the local dailies. She contended that the fact that the members of the County Assembly, whom I'll refer to as MCAs, vetted her, was in itself a form of public participation. We considered Article 10, Article 174, and Article 196 of the Constitution, Sections 87 of the County Governments Act, and the provisions. We also considered the importance of public participation as was considered in the case of Doctors for Life International, among other cases that you'll have an opportunity to look at when you get the judgment. We have considered the evidence provided by the parties hearing and note that on 8 January 2021, the Nairobi City County Assembly placed an advertisement in the Daily Nation newspaper informing residents of the impending vetting of Honkananu scheduled for 15th January 2021. We have given the extract of the advert in this judgment. We do find that through the advertisement, the County Assembly provided clear information regarding the impending vetting of Honkananu. Members of the public were given information on how and where to submit their views, contrary to the assertion by Hon Sonko that the notice did not meet the requirement of Section 7, Subsection 5 of the Public Appointments County Assembly's Approval Act, that the Select Committee on Appointment gives the public 7 days notice before vetting. This requirement was indeed fulfilled. In seeking to find out whether the need for public participation was met, the court has to look at the circumstances of each particular case. Public participation is both qualitative and quantitative. The circumstances of this case are that the nomination of Honkananu was done in January 2020, and the public was all along aware of her impending vetting, which had unfortunately stalled as a result of the orders issued in the Agoro case. Upon the lifting of the restraining orders, the County Assembly once again notified members of the public that the nominee would be vetted on 15th January 2021. There is uncontroverted evidence placed before this court by Honkananu through her replying affidavit sworn on 22nd January 2021 to the effect that she appeared before the Select Committee on Appointments on 15th January 2021. The County Assembly order paper for the same day had one of its orders of business as a motion to adopt the report of the Select Committee on Appointments of the vetting for the position of Deputy Governor. It is therefore our finding that the requirement for public participation was met. So I will turn to consider the import of Section 32D of the County Governments Amendment Act 2020 and the Public Appointments County Assemblies Approval Act on the appointment of Honkananu. The first petitioner submitted that Section 32D of the County Governments Amendment Act 2020 was not complied with, as there was no substantive governor in office to appoint Honkananu after the conclusion of her vetting by the County Assembly. It was his contention that the stated provision vests the power to appoint the Deputy Governor upon the Governor. The 8th and 9th petitioner submitted that Section 32D of the Act is applicable to the process of vetting and appointing, as it was done after the Act was enacted on 9th July 2020 and came into force on 27th July 2020 when the office of the Deputy Governor was vacant. According to the two petitioners, the cited provisions as read with Section 4 of the Public Appointments Act required that upon the vetting of Honkananu by County Assembly, there was need for a governor to complete the process by way of a formal appointment into office, and that such appointment should be in writing under the county seal. It was the petitioner's position that the crucial step of appointment was bypassed, as Honkananu was not formally appointed after the vetting process, since there was no sitting governor to appoint her. The 10th petitioner echoed the submissions of the other petitioners that the process of vetting and appointing of Honkananu was an illegality for failure to comply with Section 32D of the Act. Hon Sonko joined hands with the petitioners and contended that there is no way Honkananu's appointment could have crystallized legally without a sitting substantive governor appointing her, because an acting governor cannot execute such a mandate. Honkananu was not averse to the suggestion by the petitioners that Section 32D applied to her appointment, but argued that it applied from the time of the Act coming into force. She additionally argued that by dint of Section 32D, subsection 3 of the Act, she was deemed to have been appointed as Deputy Governor upon the lapse of 14 days from the date of her approval by the County Assembly. On his part, the third respondent argued that Section 32D of the County Government's Amendment Act 2020 should not be applied to the nomination of Onkananu, which happened on February 2020 prior to its enactment in July 2020. We have reproduced the provisions of Section 32D of the Act in this judgment. We have also reproduced Section 4 of the Public Appointments County Assembly's Approval Act. And we note that prior to the enactment of Section 32D, the Supreme Court gave guidance in the County Assembly of Embu case on the procedure to be followed in the appointment of a person to fill the vacancy in the office of Deputy Governor. We have highlighted the relevant portion of that decision in this judgment. In the said judgment or opinion, or the advisory opinion, the court went ahead and held that after approval by the County Assembly, the only remaining step was for the Deputy Governor to take an oath of office. Section 32D appears to have adopted the opinion of the Supreme Court in the advisory opinion. A reading of that section clearly shows that a governor can only appoint a Deputy Governor with the approval of the County Assembly. Our reading of the provision does not support the suggestion by the petitioners that there has to be a formal appointment once the County Assembly approves the nomination. The petitioners have, however, referred to the Public Appointment County Assembly's Approval Act, which at Section 4 requires the approval of the County Assembly for any appointment made under the Constitution or any other law. Section 11 of the same Act, we have highlighted the provisions of Section 11 of the same Act in this judgment. Under the said Section 11, the appointing authority is required to make a formal appointment upon receiving approval of the County Assembly. There was the Speaker of the County Assembly who was then acting as the Governor. It does not follow that where a County Assembly approves a nominee for the position of Deputy Governor and the specific Governor who made the nomination is unable to complete the appointment process. Sorry, I'll take that again. It does not follow that where the County Assembly approves a nominee for the position of Governor and the specific Governor who made the nomination is unable to complete the appointment, then the entire process is rendered a nullity. In our view, whoever comes in to replace the Governor who made the nomination can complete the process by appointing the approved Deputy Governor. We also observe that as at 9th March 2018, when the Supreme Court made its advisory opinion, the Public Appointment County Assembly's Approval Act 2017 had come into force 1 year earlier on 29th March 2017. According to the advisory, once a Deputy Governor is nominated and subsequently approved by the County Assembly, the only remaining step is the swearing in of the nominee, and this is what happened in the present case. It is undisputed that Onkananu took oath of office of Deputy Governor in compliance with Article 74 of the Constitution and Section 30, subsection 1 of the County Governments Act. It is also important to appreciate that we are dealing with an appointment that straddled two legal regimes, having been initiated under the parameters of the Supreme Court's advisory and concluded under Section 32D of the County Governments Amendment Act 2020. There was therefore nothing wrong with the conclusion of the appointment process under the law that was operational at the commencement of the process. We therefore find no merit in the suggestion that there ought to have been a formal appointment of Onkananu after her approval by the County Assembly. And turning to the powers of the Speaker of the County Assembly under Article 182 of the Constitution, on this issue, on the issue of whether the Speaker, while acting as a Governor, can appoint a Deputy Governor whose nomination was ongoing when the Governor is impeached, the first petitioner made reference to Article 146, Sub-Article 2 of the Constitution and submitted that the Speaker of the National Assembly, while acting as the President, pursuant to the provisions of that article, cannot reconstitute the national government or otherwise exercise the powers of an elected president. He urged the court to draw parallels from the said provision and find that a speaker of a county assembly acting as a governor pursuant to the provisions of Article 182, Subarticle 5 of the Constitution cannot exercise the powers of an elected governor. According to the first petitioner, the Constitution does not contemplate a situation where the speaker, while acting as a governor, can relinquish the office to any other person apart from the elected governor. On their part, the 8th and 9th petitioner submitted that the speaker, while acting as a governor, has no powers to appoint a deputy governor. They contended that the office of a deputy governor is an elective office which draws its authority and legitimacy directly from the people, as opposed to the speaker who is elected by members of the county assembly, and it would be a constitutional absurdity for the speaker to appoint a deputy governor. The 10th petitioner joined issue with the other petitioners and argued that the speaker cannot appoint a deputy governor as the position is elective, not appointive. We find that the submission by the first petitioner that Article 146 denies the Speaker of the National Assembly, while acting as president, powers to reconstitute the national government or otherwise exercise the powers of an elected government, not to be supported by that provision. We will let the article speak for itself, and we have placed it here in the judgment. We, however, note that Article 134 of the Constitution, which we have also highlighted, the stipulations, alongside Article 147. So from the cited provisions, we note that they are applicable to a situation where the president is temporarily absent or incapacitated, or where he or she decides that the deputy should act. This scenario is not permanent, as the president is expected to come back to office and cannot be equated to a situation where the Speaker of the National Assembly is acting as the president for a period of 60 days pending the holding of the presidential election. We find no useful insights which can be of help to the petitioner's argument I'll take that again. We find that no useful insights which can be of help to the petitioner's argument can be gleaned from the above scenario. The first petitioner relied on Section 32, subsection 4 of the County Governments Act 2012 to support his argument that the Speaker, while acting as a governor, cannot exercise the full powers of the office of governor. We have highlighted that provision here, and also Article 179, Subarticle 5 of the Constitution, which provides as follows: when the county governor is absent, the deputy county governor shall act as the county governor. The cited constitutional and statutory provisions are similar to Articles 134 and 147, Subarticle 3 of the Constitution, which we have already discussed above. They apply to a situation where the governor is temporarily absent from office and cannot be equated to a situation where the governor has permanently left office. The petitioner's argument is essentially that a Speaker of the County Assembly, while acting as a governor, has limited authority in performing the functions of that office. Their argument is that one of the limitations is that he cannot appoint a deputy governor. Under normal circumstances, this argument is correct, in the sense that the Speaker is holding the office as he awaits the election of the governor within 60 days. In the present case, however, we are not dealing with a perfect case scenario. Had Onkananu been vetted and approved or disapproved upon nomination, the current predicament would not have arisen. In that case, should have been a deputy governor before the impeachment, or in the alternative, Sonko would have nominated someone else. Taking into consideration all the prevailing circumstances, the pending process of vetting of Onkananu cannot be wished away. The process was stopped through a court order, and none of the actors in this case can take blame for that state of affairs. It cannot therefore be held that the impeachment of Sonko extinguished the nomination of Hon Kananu. Having reached the conclusion that the process of appointing Hon Kananu did not violate the Constitution, it follows that the Speaker, who was then acting as Governor, was allowed by law to do anything that would bring that process to fruition. In that regard, we are guided by the provisions of Article 259, Subarticle 3A and B, which stipulates as follows, and I'll quote that section: "Every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, a function or power conferred by this Constitution on an office may be performed or exercised as occasion requires by the person holding the office. Any reference to this Constitution to a state or other public office or officer or a person holding such an office includes reference to the person acting in or otherwise performing the functions of the office at that particular time." From the above analysis, we find that although the Speaker of the County Assembly, while acting as a governor under Article 182, Subarticle 5 of the Constitution, has no power to appoint a deputy governor, the peculiar circumstances of this case entitle the Speaker of Nairobi City County Assembly to complete the ongoing process of appointment of Hon Kananu as deputy governor. The process had been stopped by the court in the Peter Agoro case, and it is the same court which vacated the conservatory orders, hence allowing the process to proceed to its legitimate and logical conclusion. Had Hon Kananu not been approved by the county assembly, the gubernatorial by-election would then have been held. There were other issues which we considered, starting with the argument by some of the parties that the gubernatorial election, having not been held within 60 days from the date of the impeachment of Hon Sonko by the Senate, no election can now be held as it had been overtaken by events. There was a contrary position taken by the IEBC to the effect that a conservatory order only freezes time and cannot be equated to expansion of constitutional timelines. Interestingly, all the parties relied on the same case, which was the case of George Michael Wanjohi, to advance their competing positions. In view of our findings herein above, this issue no longer requires our extensive analysis. Nevertheless, our brief answer to the question is found in the George Michael case, where the Supreme Court held, and I quote, "Consequently, any statutory process or act done will traverse the provisions of the Constitution. This court will not hesitate to declare them void. Hence, a stay order will not be tantamount to stopping a constitutional process." I'll end the quote there. We therefore agree with the IEBC's position that a court's order staying the occurrence of a constitutional event does not amount to a breach of the constitutional timelines. We cannot imagine a situation where an event ordained by the Constitution will not occur simply because it has been postponed. Another issue was the request by the 7th and 8th interested parties for this court to expunge any reference to them in Hon Sonko's pleadings. This request is indeed available under Order 2, Rule 15, and Order 19, Rule 6 of the Civil Procedure Rules. We have in this judgment already made our determination regarding the veracity of Hon Sonko's pleadings and averments over this issue. Our view is that the averments and pleadings of Hon Sonko conveyed his case as he perceived it. The power to strike out pleadings and averments should be exercised cautiously, lest the right to access justice is interfered with. Our determination that Hon Sonko's pleadings in relation to the 7th and 8th interested parties are unbelievable is sufficient protection of their right to correction and deletion of untrue or misleading information. Any infringement of the right to privacy can be pursued through other processes or litigation. Regarding the issue as to whether the IEBC violated the law by publishing Gazette notice calling for by-election for the position of Governor of Nairobi City County, we do find that the action of the IEBC are a direct consequence of the letter from the Speaker of the County Assembly informing the Commission of the vacancies in the offices of the Governor and Deputy Governor. We observe that as at the time of the impeachment of the governor, the process of appointment of the nominated deputy had been stayed by a court, but was soon thereafter reactivated. It is therefore our finding that the IEBC cannot be faulted for calling for the by-election. As we have already stated in this judgment, a by-election would have indeed been conducted if Honkananu had not been approved by the County Assembly. Before we leave this issue, we find that an order of certiorari quashing the Gazette notice is no longer necessary in view of our findings. So, having regards to the above analysis, it is our finding that the nomination, vetting, approval, and swearing in of Honkananu as the Deputy Governor was constitutional and complied with the applicable laws. Consequently, we find that all the petitions challenging her ascendancy to the position of Deputy Governor are without merit and are hereby dismissed. Conversely, our above holding is sufficient to take care of the prayers in Honkananu's cross petition and that of the fourth petitioner, Josephat Kariuki. On costs, the general rule as provided under Section 27 of the Civil Procedure Act is that costs ordinarily follow the event unless for good reason the court orders otherwise. The consolidated petitions are in respect of a novel issue concerning the governance of county governments. The appropriate order in the circumstances is to direct each party to bear their own costs. Before we sign off, we take this opportunity to appreciate the parties and their advocates for their industry and research in this matter. These are the orders of the court.
Most obliged, my lady. Most obliged, my lady, my lord. On behalf of the fascist party, my lady, my lord. Mrs. Harrison, to request for the certified copies of the proceedings and the judgment.
The third interested party, Katiba Institute, joins in that request.
Your Lordship, also on behalf of the 10th interested party, Short Munguko, we also wishes to apply for the proceedings and ask for a copy of the judgment.
Also, the 10th petitioner wishes to apply for proceedings and a copy of the judgment.
My Lord, the 8th and 9th petitioner also wish to ask for a copy of the proceedings and the judgment.
Your Lordship, also for the third petitioner, we wish to request for copies of the same.
So, copies of certified proceedings and judgment to be supplied as prayed to all the parties who shall ask for them upon payment of the requisite fee. There was somebody talking. Okay.
My Lord, given that copies of judgment are not immediately available, and given that the court indicated that the same will be available at the earliest on Monday, my Lord, parties may be inclined to challenge the decision of the court, yet they may not be. They may not have.
Mr. Nyamu, sorry for cutting you short. This judgment will be available online in the next 30 minutes. We are not adding anything, and as soon as we pen off, you can call our court assistants for copies. They can photocopy and give you a raw document where you can. It has been signed. We do not wish to. The judgment is okay. What will have problems will be the proceedings. Yeah. It will be sent online shortly after we leave.
I'm guided, man.
Okay. So we go to 425. Can we take the quorum in this judgment? We have on Mike Sonko, Kia Umtata, who is appearing?
My Lord, my name is Okiwa Mtoto Korti, the second petitioner in the consolidated petitions.
Yes.
Lord, I'm a learned friend, Mr. Nyamu. Mr. Nyamu, you are addressing the court.
Yes, my Lord, in this matter, my name is Wilfred Nyamu, and I do appear together with my learned friends, Mr. Harrison Onyenjui, Mr. Evans Odieki, Dr. Hamino, Professor Mikai Aket, and Mr. Alphonse Mutina for the first petition.
Wait.
Clerk, Nairobi City County.
Praise my Lord and my lady.
Yes.
My name is Ostundwa. I appear together with Ms. Shaunda.
The Speaker of the Nairobi City County.
My Lord, we demand that for the Speaker of Nairobi City County Assembly, the second respondent.
Nairobi City County Assembly. The first one was the clerk. Third respondent.
Your Lordship, my lady. My name is Ashia for the third respondent.
Fourth respondent, Senate, Speaker of the Senate of Clerk, Speaker. Yes, Ms. Tanji.
Yes, my Lord, I am present.
The AG.
My Lord, Ms. Ndong, present.
Mambo.
IBC.
My Lord, in this one I appear, Mukele, my Lord, Mukele.
Yes.
I appear together with Mr. Mahmoud Jabane for the IBC, my Lord.
Assumption of the office of the County Governor Committee.
May it please do my lady and my lord. My name is Okach. I do hold brief for Mr. Ndwega, who appears
for the 9th respondent.
10th respondent.
On my part, my lady, my lord, my name is Okach. I do appear for the 10th respondent in the matter.
Have we left anybody?
Those were the appearances and have been the appearance. So everyone is accounted for.
Okay, I will use the same procedure. So this is the judgment of the court. We have introduced the subject and all the parties. There were 2 petitions and the same were consolidated. We have explained the first petitioner's case. The 2 petitions are more or less the same, but we have explained what they contain and their respective prayers. We have given a long analysis of the petitions. Then we have come to the respective submissions of the first petitioner and the second petitioner, the issues they raised. The first petitioner raised the issue whether the court has powers to review decisions of the county assemblies and the Senate, and whether such review violates the separation of powers. The submissions to that effect. Second issue, whether the Senate met the constitutional threshold for impeachment. We have explained, this is the petitioner's case. So see whether the Nairobi City County Assembly and the Senate violated the first petitioner's right to fair administrative action. We have given the case by the first petitioner, whether the requirement for public participation was complied with, whether the removal of the first petitioner from office was conducted in accordance with the Constitution and the law. That is part of and the authorities cited. We have also explained and summarized. The second petitioner's submissions, more or less the same but with a different angle. We have explained that. The respondent's case, the first respondent, the clerk, Edward Obori, Gichana, the governments, and the submissions have been considered. The first respondent submissions, we have considered them. Then we have the second respondents on Benson Mutura, Speaker of the County Assembly. There was a long affidavit and annexures. We considered them and the submissions equally. According to him, the issues raised is whether the impeachment motion was validly lodged, whether there was non-compliance with any court order, the quorum and voting system, and the remedies. The third respondents mainly filed submissions, and the issues he raises is whether the first petitioner was lawfully and or regularly impeached, whether the petitioners have made a case for the grant of the prayer sought. The fourth, fifth, and sixth respondents' case, we have explained it and their submissions. The seventh respondent's case, the AG, opposed the petitions through grounds of opposition. We have seen those ones plus the submissions. The eighth respondent's case filed a replying affidavit sworn by Michael Goa on 16th April in response to the petitions. We have analyzed that one plus the brief submissions. The 10th respondent's case, we have briefly analyzed, because he had two caps, one as the speaker and another one as the acting governor. So we have one paragraph for him as the acting governor. So this is the analysis. I will read where necessary. We have carefully considered the pleadings, the written and oral submissions, and the authorities of the parties. We have also considered all the issues as framed by the parties. In our view, we are required to first determine whether we have jurisdiction to determine the petitions. If we establish that we have jurisdiction, the key issues that we are required to determine are whether the first petitioner was accorded fair administrative action during the impeachment proceedings, and whether the impeachment met the constitutional threshold. So the first issue of jurisdiction, the Speaker of the County Assembly is of the view that impeachment of governors is the preserve of the Senate and county assemblies, maintained that the impeachment process, having complied with the constitutional and constitutional requirements, this court is barred by the doctrine of separation of powers from entertaining the petitions. The Attorney General also was of the same view. The petitioners took a contrary view to that of the respondents. The petitioners asserted that the conduct of the County Assembly was so perverse that it amounts to the violation of the Constitution, thereby requiring intervention of this court. We have explained all that in discussing the doctrine of the separation of powers. We have gone to the Supreme Court in the case of the matter of the Interim Independent Electoral Commission Advisory Opinion number 2 of 2011, and we have captured one of the paragraphs there. The Court of Appeal also took a similar issue in Mumomatemo, the case of Doctors for Life. So, guided by the above cited decisions, we find that the doctrine of separation of powers does not inhibit this court's constitutional power to examine and interrogate the impeachment proceedings of the County Assembly and the Senate where a party alleges that there was violation of the Constitution and the law. This finding leads us to the inevitable conclusion that this court has the jurisdiction to hear and determine the petitions. So the second issue has several subtitles. So the first one is fair administrative action. In addressing the issue as to whether the first petitioner was accorded fair administrative action during the impeachment proceedings, this court is called upon to consider whether there was a proper notice of motion for impeachment before the County Assembly, whether the first petitioner was properly served with the said motion, whether there was quorum in the County Assembly during the debate and the voting on the motion, whether there was fair hearing both at the County Assembly and the Senate. The first petitioner contended that the action of the County Assembly to receive the motion, debate and pass a resolution impeaching him as the governor contravened the Constitution, particularly Articles 1, 10, 48, 50, 174, 182, 196 and 200. It was submitted that the motion dated 25th November 2020 was not verified or accompanied by sworn affidavits of the MCAs supporting it, and that this violated the Constitution and the County Assembly Standing Order number 67. And also there was mention of Standing Order number 72. Another aspect of the above issue is the first petitioner's contention that at the time the motion mover Hon Michael Ogada Okumu presented his motion, there was already a pending motion by Hon Peter Imwatok that had been stayed by the court in the Employment and Labor Relations Court case number 35 of 2020. It was also submitted that the motion was debated on 3rd December before the expiry of the 7 days period provided by County Assembly Standing Order 67-4. The respondents of the contra review. It is submitted that an impeachment motion is a special motion that has to be disposed by the Speaker within seven days of receipt from a member and deliberated upon within 3 days following approval by the Speaker. Towards the respondent's position that a special motion lapses if there is failure to comply with the set timelines. According to the respondents, the motion by Hon. Imwatok had lapsed by the time the second motion was lodged. Standing Order 67 of the County Assembly provides for the procedure for the presentation of a motion to impeach the Governor. The record shows that the motion by Hon. Michael Ogada was delivered to the clerk on 25th November 2020 and received by the Speaker the following day. Standing Order 67 stipulates as follows. We have reproduced, it's not a long section. Upon the expiry of 7 days, after notice given, the motion shall be placed on the order paper and shall be disposed of within 3 days, provided that if the County Assembly is not then sitting, the Speaker shall summon the Assembly to meet on and cause the motion to be considered at that meeting after notice has been given. Standing Order 67 is titled Procedure for Removal of Governor by Impeachment. This is the law that should guide the County Assembly when deliberating on an impeachment motion. The respondents have correctly pointed out that under Standing Order 49, an impeachment motion is a special motion which has to be disposed of by the Speaker within 7 days of notice from a member. We nevertheless observe that Standing Order 49-2 permits a lesser or longer period as specified by the Constitution, any written law or standing orders. Standing Order number 67-4 provides that an impeachment motion shall only be placed on the order paper upon expiry the provision to be followed in the impeachment of a governor. Article 259 of the Constitution provides for the manner in which the Constitution should be interpreted. Of relevance to us are subtitles 5 and 6. We have reproduced those two subtitles of Article 259. Applying Article 259(6) to Standing Order 67-4, we find that the notice of 7 days required therein includes Sundays and public holidays. From the record, the motion by Hon. Ogada was presented to the clerk on 25th November 2020 and approved by the Speaker on 26th November 2020. Under Order 67-3, upon approval of the motion by the Speaker, the mover shall give a 7 days notice calling for the impeachment of the Governor. By virtue of Article 259(5)(a), 26 November 2020 is excluded from the 7 days period. However, the 3rd of December 2020 is included. We find, therefore, that the 7 days period requirement was complied with. Standing Order 67-1 requires that the motion be verified and signed by at least 1/3 of the MCAs to confirm that the particulars of the allegations contained in the motion are true to their own knowledge. The evidence on record shows that the notice of motion delivered to the office of the clerk was supported by 86 MCAs who appended their signatures to it. The first petitioner's position was that the motion presented before the County Assembly was not properly verified by the move of the motion as well as by 1/3 of the members of the County Assembly. He submitted that the mover of the motion ought to have affirmed in a deposition the veracity of the allegations made in the notice of motion, but failed to do so. It is alleged that there were no verification forms signed by each of the 1/3 of the members of the County Assembly. We have perused the motion together with a list containing 86 names and signatures of the MCAs who supported it. We note that none of the signatories came forward to dispute the same. In our considered view, by signing the motion, a member confirms its veracity. It will be absurd to expect an MCA to go and swear an affidavit before a commissioner of oaths in support of a motion he/she intends to move before the county assembly. There is the argument of Mr. Emmanuel Kenga that the first petitioner's advocate, Mr. Evans Ondiek, sent him a list of 88 names with a request for a forensic analysis in order to determine if the list was generated by the same person. We have examined the handwritten list of the MCAs who supported the motion and note that it is the same list sent to Mr. Kenga. According to Mr. Kenga, only 5 entries in the list were made by the same hand. We observe that none of the 5 MCAs identified by Mr. Kenga has disowned the entries. Furthermore, the report by Mr. Kenga dated 12th December 2020 found that all the 88 signatures on the list were all, we are quoting the report, were all written in different styles. They were written by different authors. The above finding by the first petitioner's expert witness leads us to the logical conclusion that each MCA signed against his or her name. In any event, in order to achieve the 1/3 threshold, only 41 of the 122 MCAs were required to support the motion, and we therefore find that the motion had the support of more than 1/3 of the MCAs. Another aspect of that issue is whether two impeachment motions existed concurrently. We note that the order by Justice Ongaya of 2nd March 2020 was to the effect that the Imwatok motion that was scheduled for debate on 3rd March 2020 could proceed as long as there was strict compliance with Standing Order 67 and 72. Our understanding of the court order is that the deliberations on the motion was not stopped, as the court order simply required compliance with the law. For the above reasons, we find that by the time the Ogada motion was presented in November 2020, the Imwatok motion had lapsed for not being processed within the timelines as provided under Standing Orders 49 and 67. Another issue is on whether the impeachment motion was supported by 2/3 of the MCAs as required by Section 33(2) of the County Governments Act and Standing Order 67. The petitioners contended that there was no quorum during the deliberation of the motion on 3rd December 2020. Their case is that there was need to have at least 2/3 out of the 122 MCAs physically present in the chamber during the debate. According to the petitioners, this number could not be attained because 57 MCAs were with the first petitioner in Kilifi County. It was also the contention of the petitioners that the gazetted chamber for the county assembly is located in Nairobi, and no member could have participated in the debate if not in Nairobi. The respondents of the contrary view and submitted that the standing orders had been amended to allow for virtual proceedings and voting. According to the respondents, it was therefore not a mandatory requirement that all members of the assembly be physically present in the chamber in order to vote. We note that on 2nd June 2020, an amendment was introduced via Standing Order 231D titled Use of Technology. The amendment enabled the Speaker to conduct virtual proceedings. Standing Order 231D3 allowed MCAs to vote virtually. It is our finding that there was therefore no requirement for the MCAs to be physically present in the chambers in order to vote on the motion. This finding also answers and convinces us to reject the petitioner's assertion that voting is only available to members physically present at the county assembly chambers where the mace, the symbol of authority, the mace, is located. Additionally, this court takes judicial notice of the advent of virtual proceedings as a mode of conducting business in response to the COVID-19 pandemic, and therefore the physical presence of the MCAs in Nairobi is no longer necessary we find that while some of the MCAs were physically present in the chamber during the debate and voting, others attended the session virtually. Still on the issue of quorum, the petitioners allege that 57 MCAs who were with the first petitioner in Kilifi County did not participate in the voting. On their part, the respondents argued that logging credentials were availed to all MCAs who subsequently voted virtually. Further, that the petitioners did not provide any expert evidence to support the allegation that the virtual accounts of some of the MCAs were hacked. It is further argued that the identities of the 88 MCAs who voted in favor of the motion and how they voted is not verifiable, hence failing the requirement of Article 10 as read with Article 81 of the Constitution. According to the petitioners, the voting process lacked integrity as accounts of some MCAs were used without the authority. Although the first petitioner averred that he had annexed affidavits of 57 MCAs who claimed that they did not vote virtually, the court record reveals that he attached 39 such affidavits sworn by the following MCAs. We have written those MCAs plus their ID numbers. From number 1, I don't have to read the lists, up to number 39. In his replying affidavit, the Speaker of the County Assembly annexed affidavits in which 24 out of the same 39 MCAs listed herein above averred that they voted on the impeachment motion on 3rd December 2020. The provided list contains the following names. We have put the names and the ID numbers. These are 24 MCAs ending with Honorable Evans Otiso. So the court is now left with two separate sets of affidavits that present contrary positions. On the one hand, some MCAs averred that their logging credentials were forged and that they never participated in the voting process on 3rd December 2020, and even went to the extent of making a report at the Kwale police station. On the other hand, 20 out of the same 39 MCAs saw fresh affidavits on 4th December stating that they willingly voted on 3rd December 2020. The Hansard, which is the official record of the County Assembly, shows that 90 MCAs voted in respect to Hon Ogada's motion. In view of the contradictory averments by some of the MCAs who were alleged to have been in Kwale, coupled with lack of an expert evidence to support the alleged hacking, we find that the petitioners did not establish that the 2/3 statutory requirement for impeachment of a governor was not met. It is Strite's law that he who alleges must prove, and it was incumbent upon the petitioners to provide evidence in support of their averment that the 2/3 requirement was not met. Another issue is on the breach of the right to fair hearing under Article 50 of the Constitution. The first petitioner submitted that he was not given a hearing before the County Assembly as he was not furnished with the charges and accorded adequate time to prepare for his defense. Further, that he was not furnished with any evidence to support the purported impeachment proceedings and that his counsel was denied access to the County Assembly chamber during the impeachment proceedings. The first petitioner further contended that the entire impeachment process was rendered void and invalid since there was breach of Section 3 and 4 of the Fair Administrative Action as well as Article 47 of the Constitution. The second respondent maintained that the County Assembly complied with Standing Order 67 during the hearing of the impeachment. It is his submission that the first petitioner did not inform him in advance that he would send an advocate to represent him during the hearing of the impeachment motion. Further, that Mr. Evans Ondiek did not have any document or proof that he had been instructed to act for the first petition. According to the Speaker, since the first petitioner had been invited to attend the session virtually, the governor ought to have officially notified him that he had appointed an advocate to act for him, so as to avoid a situation where the governor disowned the representation by the advocate. Article 47 of the Constitution provides for the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. It also requires that if a right or fundamental freedom of a person has been or is likely to be adversely affected by administrative action, the person has the right to be given written reasons for the action. The right to fair hearing under Article 50 of the Constitution provides that every person has the right to have any dispute that can be resolved by the application of the law decided in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal or body. We have reproduced Section 4 of the Fair Administrative Action Act. We have also reproduced Section 33 of the County Governments Act number 17 of 2012. We have also reproduced County Assembly Standing Order 72, which provides for fair administrative action where there is removal of an officer. The Senate recognizes the right to fair hearing while considering a petition for removal of a person from office under its Standing Order number 76, which we have also produced. The right to fair administrative action under Article 47 and the right to fair hearing under Article 50 have been the subject of several judicial decisions. In the case of Ridge versus Baldwin, Appeal Cases 1964, the House of Lords stated that the rules of natural justice, in particular right to fair hearing, or the alteram partem rule, applied not only to bodies having a duty to act judicially, but also to the bodies exercising administrative duties. The House of Lords distilled three ingredients of natural justice as the right to be heard by an unbiased tribunal, the right to have notice of charges of misconduct, and the right to be heard in answer to those charges. In the case of Judicial Service commissioned by Mutava, the Court of Appeal, we have cited that case. We have also cited the case of Walid Khalid versus County Assembly of Mombasa and two others. We have also referred to Dry Associates Limited and also referred to the case of Regina versus Secretary of State for the Home Department. We have also referred to County Assembly of Kisumu and two others versus Kisumu County Assembly Public Service Board and 7 others. They are lengthy paragraphs, so you will read. As I have said, it will be available shortly. In the Republic versus Clark County Assembly of Baringo, expert William Kamkets, there is a paragraph which states as follows, quite clearly, removal of a speaker must follow a fair administrative action. The rules of natural justice must apply. The office is ring-fenced by requiring disclosure of grounds or reasons for removal, service of notice, and a very high threshold to carry the motion. In light of the above cited authorities, our standing of the law is that the right to fair administrative action applies in both judicial, quasi-judicial proceedings, or any administrative process that affects the right of an individual. As the adage goes, no man should be condemned unheard. It therefore follows that any person or administrative body exercising a judicial or quasi-judicial function must ensure that the affected party is accorded the right to be heard. This calls for the issuance of a notice detailing the allegations against the affected person or persons, sufficient time to make a response, ample time to be heard by an impartial tribunal, the right to legal representation, and where necessary, provision of the reasons for the decision. These are the standards that the Senate and the Nairobi City County Assembly were expected to comply with. Applying the above standards to the present case, we find that the first petitioner was notified of the charges against him through the Speaker's letter dated 26 November 2020. We have perused the said letter, which we observe was accompanied by a copy of the motion detailing the charges leveled against the first petitioner and the list of MCAs who supported the impeachment motion. We note that the motion sufficiently explained the charges made against the first petitioner. Our finding is that the first petitioner was accorded the opportunity to respond to the charges, and that explains why he sent his advocate with bundles of documents to counter the charges. We note that the impeachment process is a quasi-judicial exercise where the MCAs are the umpires. This means that they were expected to make a decision on the motion. It therefore defeats logic as to why the first petitioner opted to ferry the MCAs to Kwale County, yet they were expected to make a resolution on the motion. Instead of joining the proceedings using the link sent to him or appearing in person, the first petitioner opted to watch the proceedings live on television and processed a video to that effect. The first petitioner's actions portrays him as a man who was fully aware of the case against him, but was out to frustrate the impeachment proceedings, and it cannot therefore be said that he was not accorded an opportunity to be heard. Moreover, his action of taking away the MCAs was in clear violation of Section 28 of the County Assembly's Powers and Privileges Act, which provides as follows: a person shall not by fraud, intimidation, force, insult, or threat or of any kind, or by the offer or promise of any inducement or benefit of any kind, or by any other improper means, influence a member in the performance of the member's functions as a member, induce a member to be absent from a county assembly or a committee at a particular time, or attempt to compel a member to declare himself or herself in favor or against a matter pending before or proposed or expected to be submitted to a county assembly. A member shall not solicit, receive, or accept any fee, compensation, gift, reward, favor, or benefit of any kind for the member or another person for in respect of voting in any particular manner or not voting on a matter before a county assembly, promoting or opposing anything pending before or proposed or expected to be submitted to a county assembly, making a representation to a county assembly. A person who contravenes this section commits an offense. In conclusion, we find that the motion which sufficiently contained the charges was served upon the first petitioner. The notice period was in compliance with the county assembly standing orders. The first petitioner was clearly informed that he could appear in person or through a legal representation, and was facilitated to defend himself virtually via a link. We are therefore satisfied that the impeachment process complied with the constitutional and statutory requirements. I will let my sister continue. We have about 45 more pages. This is the analysis. That's why we want to read each and every sentence. So my sister will continue from there.
So I will start from the issue of public participation. The first petitioner submitted that contrary to the requirements of the Constitution, both the Senate and the County Assembly failed to ensure public participation in the process of removing him from office. It was additionally the first petitioner's position that it has not been demonstrated that the Senate gave the public appropriate information and opportunity to participate in the impeachment either prior or during the debate. The first petitioner's case is that the removal of a governor is not any other business of a county assembly, and the electorate ought to be involved since a governor is directly elected by the voters in the county. On his part, the second petitioner submitted that failure to subject the removal process to public participation was fatal. He accused the county assembly of not adducing any evidence to show that there was public participation in the impeachment process. In response, the petitioners claim that the principle of public participation was not complied with, the county assembly insisted that there was adequate public participation. The Speaker of the county assembly supported this position. On their part, the fourth, fifth, and sixth respondents were of the view that the requirement for public participation was complied with by virtue of the fact that the proceedings were open to the public. One of the main pillars of the Constitution is the principle of public participation, which allows people to have a say in the manner in which they are governed. This applies both at the national and devolved governments in their legislative and policy functions. Public participation is a cornerstone to democratic governance, as evidenced by its listing among the national values and principles of governance under Article 10 of the Constitution. Article 118 of the Constitution requires Parliament to conduct its business in an open manner and facilitate public participation and involve legislative and other business. Amongst the objects of devolution, as provided for under Article 174 of the Constitution, are to give powers of self-governance to the people and enhance the participation of the people in the exercise of the powers of the state and in making decisions affecting them, and to recognize the right of communities to manage their own affairs and to further their development. Article 196 specifically commands county assemblies to conduct their business in an open manner and to hold their sittings and those of their committees in public, and in particular to facilitate public participation and involvement in the legislative and other business of the assemblies and their committees. Additionally, the County Governments Act 2012 at Section 87 provides for the principles upon which citizen participation shall be based. These include timely access to information, reasonable access to the process of policy and law formulation, and protection of the rights of the minorities. Section 115 of the same Act provides for mandatory participation and facilitation of the public in planning processes through specified mechanisms by providing clear and unambiguous information on any planning process, as well as developing laws and regulations to give effect to public participation. We considered the case of Doctors for Life, where the principle of public participation was interpreted by the South African Constitutional Court. We also considered the decision in Mui Coal Basin Local Community and 15 others, where the principles were summarized. So the nature, extent, and amount of public participation that is acceptable was discussed in the South African case of Matatiele Municipality and others versus President of Republic of South Africa. And back here at home in Wambora, case at the Court of Appeal, we have referred to it as Wambora Court of Appeal 2, where the necessity of public participation in impeachment proceedings was emphasized. Guided by the above-cited cases on the issue of public participation, we now turn to consider the evidence placed before this court over the same. The first petitioner relied on the affidavit of Mr. Newton Munene Njiru, the Nairobi City County Chief Executive Officer in charge of information technology and communications, to support the argument that public participation was not undertaken. Mr. Munene averred that there was no online platform that could have enabled the residents to participate in the impeachment process. There was no committee report evidencing that there was any public participation at the committee level. He also stated that there was no single FM radio or TV station advert inviting the public to engage in the impeachment proceedings, and that the charges leveled against the governor were not uploaded in the County Assembly website. Mr. Munene further averred that the first petitioner's advocate notified him that by 2nd December 2020, about 40,000 memoranda from Nairobi residents had been received by his law firm opposing the impeachment. He averred that none of the memoranda was acknowledged or even canvassed during the impeachment proceedings of 3rd December 2020. We note from the affidavit of Mr. Munene that he introduced himself as the CEC in charge of Information Communication Technology and E-Government ICD Department. His averment was in respect to the executive arm of the county government and cannot be taken to be the position of the County Assembly. Indeed, the County Assembly in its report titled Public Participation Findings Impeachment Motion observed as follows at part 1.0 of its report, and I'll quote, "It has been noted that the county executive commissioned a separate survey, separate from the one by the County Assembly. The said survey cannot be the basis of the public participation process envisioned under Article 196 of the Constitution, since it was not commissioned by the Assembly. As such, its findings cannot be relied upon." End of quote. According to the County Assembly, adequate notice of the impeachment was issued to Nairobi residents. Questionnaires were circulated to the residents, and a report dated 3rd December 2020 was prepared and annexed to the Speaker's affidavit. According to the report, the residents were asked if they were aware of the impeachment and if they supported it. The report concluded that a majority of the residents were aware of the impeachment motion, the reasons for the proposed removal of the governor, and that they supported it. There is also the averment that the County Assembly clerk published a notice of the impending impeachment in the daily newspapers of 27th November 2020. It was also the clerk's position that online platforms were opened to enable residents air their views on the issue of impeachment. With regard to the issue of public participation, we find that there is sufficient evidence to show that the County Assembly conducted a survey in Nairobi County seeking the views of the residents. A report to that effect was prepared and tabled before the County Assembly. We further note that on 27th November 2020, the clerk to the Assembly published the impending impeachment motion in the daily newspapers. See, for instance, page 31 of the Daily Nation newspaper, and called for the residents to deliver their representation to the Assembly physically or through provided postal or email addresses. The clerk also informed the residents that they could access the impeachment motion from the County Assembly website, which he also provided. The fact that there was sufficient public participation is indeed also confirmed by the averment of Mr. Munene that at least 40,000 residents had provided their views on the impeachment to the first petitioner's advocates. We take judicial notice of the fact that the current impeachment happened during the COVID-19 pandemic, which severely hindered interpersonal interactions and some of the avenues of public participation that require physical interaction of the residents, such as public barazas and town hall meetings, may not have been available. From the above exposition, we are satisfied that the County Assembly was aware of the needs for public participation in the impeachment process and indeed complied with the requirement. We therefore find that the constitutional and statutory requirement for public participation was met. Turning to Senate proceedings, the petitioners contended that before accepting the impeachment resolution from the County Assembly, the Senate ought to have evaluated the Assembly proceedings in order to satisfy itself that the law was complied with. They also complained that the first petitioner's preliminary objection was improperly dismissed. The petitioners also argued that the County Assembly was allowed to introduce new evidence before the Senate at the 11th hour. Another complaint was in respect to the manner in which the Senate served the first petitioner with voluminous evidence on the evening of 15th December 2020, yet he was expected to defend himself the following day. It was further submitted that the Senate was biased against the first petitioner and had a predetermined outcome. The first petitioner also contested the manner in which the Senate voted on all the 4 counts, while arguing that it was sufficient proof that the Senate was not impartial. The first petitioner also complained that he was not given the reasons for the impeachment and that no report was availed to him by the Senate. On their part, the respondents argued that all the constitutional and statutory requirements were adhered to in the entire impeachment process. So, starting with the issue of preliminary objection, the first petitioner's case was that he invoked Rule 19 of the Senate rules on removal of governor by impeachment and raised a preliminary objection. According to the first petitioner, he was not accorded an opportunity to prosecute the preliminary objection as provided under Rule 13, and that the Speaker instead invoked Rule 29 and consolidated the preliminary objection with the impeachment proceedings. The grounds of the preliminary objection were that the issues discussed in the impeachment motion were sub judice within the meaning of Senate Standing Order number 98, as they were subject to active court cases, that there was a conservatory order in ELRC petition number 35 of 2020 prohibiting the county assembly and the Senate from proceeding with any impeachment motion against the first petitioner, and that the threshold for impeachment of a governor had not been met. We have perused the Hansard of the Senate and note that on 16th December 2020, the Speaker indicated that there were 2 applications. One application was by County Assembly requesting that 11 other witnesses be summoned to testify before it, and the other application was a preliminary objection by the first petitioner. After brief arguments by the parties, advocates, the Speaker made a ruling in which he allowed the County Assembly to summon 3 additional witnesses. And he also made a ruling on the preliminary objection, whose extract we have reproduced in this judgment. Considering the manner in which the Speaker handled the applications before the Senate, we find that he properly dealt with the preliminary objection. A contrary finding would have meant that the Senate would not have proceeded with the impeachment until all the cases filed by the first petitioner were heard and determined. We find that the Senate exercised its constitutional mandate in dealing with the impeachment, which was subject to stringent timelines. The decision by the Speaker cannot be said to have violated the first petitioner's right to fair hearing, because what the Speaker did was simply to subsume the preliminary objection in the main hearing. I will turn the mic over to my presiding judge to conclude the judgment.
So there is a subtitle on the proceedings before the County Assembly on the complaint by the petitioner that the Senate ought to have first established the lawfulness of the proceedings of the County Assembly. We reiterate our finding above that the Speaker of the Senate had correctly disposed of the issue in his ruling on the preliminary objection. Additionally, we find that the deliberations of the Senate are part and parcel of its evaluation of the impeachment proceedings before the County Assembly. It is further our finding that in voting on the impeachment motion, whether as a committee or in the plenary, the senators make a decision on all the issues touching on the proceedings, including the lawfulness of the impeachment. There was the issue of new evidence. On the petitioner's complaint regarding the County Assembly's alleged introduction of new evidence before the Senate, we find that no new evidence or charges were presented before the Senate, as what was contained in the notice of motion by Hon. Ogada is the same information that was presented before the Senate. The mover of the motion reiterated what he had stated before the County Assembly. The other 2 witnesses who testified before the Senate only expounded on the charge of abuse of office and did not introduce any new issue. On 15th December 2020, the first petitioner filed a detailed response to all the allegations made against him. He was at the hearing also given an opportunity to challenge the evidence through cross-examination of the witnesses and presentation of his own testimony. We therefore find that the allegation that the Senate entertained new evidence has not been established. There was the issue that the first petitioner was served with the evidence late, with the voluminous documents on the eve of 15th December, on the evening of 15th December 2020. We established from the record that the clerk to the Senate sent invitation letters to both the County Assembly and the first petitioner on 9th December 2020, in which he called upon both parties to file their respective documents by 15th December 2020. All the parties filed their documents on 15th December 2020, and the same was duly dispatched by the clerk to the respective parties on the same date, in which case no party can claim that he was disadvantaged by such service. Whereas the County Assembly was called upon to prosecute its case on 16th December, the first petitioner had up to 17th December to defend himself. We therefore find that the late service of voluminous documents did not impinge on the first petitioner's right to fair administrative action and hearing. Voting in the Senate. Regarding the complaint on the manner of voting on the counts before the Senate, the first petitioner stated that the Senate was biased because the senators uniformly voted on all the 4 counts. He further argued that the senators had a predetermined position on the matter, going by the statement by Hon. Cleophas Malala that the Senate should not waste time on the debate as a decision had already been made. It is our finding that this was a debate before the Senate in which each senator was entitled to voice his own views. The Senate answered report does not indicate that the senators had previously met and reached a decision to impeach the first petitioner so as to justify the claim that the vote was predetermined. Since each senator was exercising his or her quasi-judicial role as an umpire in the matter, this court cannot question their decision to consistently and uniformly vote in support of or against each of the charges. In any event, even if the first petitioner was to be found culpable on only one charge, the end result would still have been the same, that the impeachment motion was successful. There is the complaint that no reasons were given for the impeachment and that no Senate report was availed to the petitioner. We find that the Senate's Hansard report contains the entire impeachment proceedings, which include the reasons for the impeachment. In our considered view, the decision by the senators to proceed by way of plenary is lawful as provided under Section 33(3)(b) of the County Governments Act and Standing Order 75, which gives the Senate the discretion to proceed through plenary or special committee. We note that where the Senate proceeds through plenary, there is no provision for the preparation of a report. It is only when the Senate proceeds by way of a special committee that the committee's report is presented to the plenary. Although it does not fall within our remit to direct the legislature on how to perform its functions, we have the considered view that impeachment of a governor is a serious undertaking, as the end result can lead to the removal of a popularly elected governor. For this reason, we recommend that it will be desirable that future impeachment proceed through the committee route as opposed to the plenary. We say so because when the special committee is appointed, it has 10 days to deliberate on the matter, thus giving ample opportunity to the parties to adequately prepare their cases. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary, which can be perceived to be a mob lynching process. This view is vindicated by the Senate Hansard, which shows that there were several interventions by the senators, thereby eating into the time set aside for the parties to present their cases. There is another issue on the threshold for impeachment. Another issue raised by the petitioners is whether the charges leveled against the first petitioner met the constitutional and statutory threshold, and if the same was sufficiently established. We not belabor the fact that this court has jurisdiction to determine whether the constitutional threshold for removing a governor has been met. We are guided by the Wambora Court of Appeal 1, where the judges held. We have reproduced several paragraphs up to paragraph 53, from paragraph 52, 48, 51, and up to 53. The Black's Law Dictionary, 11th edition, defines impeachment as the act by a legislature of calling for the removal from office of a public official, accomplished by presenting a written charge of the official's alleged misconduct. The Constitution under Article 181 provides the grounds for the removal of a governor as follows. 1. A county governor may be removed from office on any of the following grounds. A. Gross violation of the Constitution or any other law. B. Where there are serious reasons for believing that the county governor has committed a crime under national or international law, abuse of office or gross misconduct, physical or mental incapacity to perform the functions of office of a county governor. We have elsewhere in this judgment reproduced Section 33 of the County Governments Act, which provides for the procedure to be followed in the removal of a governor. The roles of the various state organs in relation to the removal of a governor were explained by the Court of Appeal in Wambora 1. We have reproduced paragraph 31, 32, 34 of that judgment. With regard to what amounts to gross violation of the Constitution, it was observed in Wambora Court of Appeal 1 that the Constitution does not provide a definition for gross misconduct. It was, however, stated that the determination of whether conduct is gross or not would depend on the peculiar facts and circumstances of each case. The court relied on the Nigerian Supreme Court decision in Hon Muyiwa versus Hon Ibrahim Adolo Adeleke for the ingredients of gross violation or breach of the Constitution, which we have reproduced. In our view, the above list is not conclusive and will, for instance, add consistent violation of court orders and failure to perform constitutional and statutory duties. Internationally, legislatures are clothed with powers to ensure that the executive perform its functions within the laws of the land and in accordance to the Constitution. One of the tools of ensuring compliance with the Constitution and the laws is the concept of impeachment. The motion presented before the County Assembly contained 4 charges, namely gross violation of the Constitution or any other law, gross misconduct, abuse of office, and crimes under national law. In respect of the first charge, the first petitioner was alleged to have violated the Constitution, the County Governments Act, the Public Procurement Disposal Act, and the Public Finance Act. Under the charge of abuse of office, it was alleged that the first petitioner had violated Article 75 of the Constitution, as read together with Sections 11 and 13 of the Leadership and Integrity Act 2012 on conduct of state officers. The governor was accused of having persistently intimidated, harassed, and molested officers of the county executive. This included blackmailing the county executive members and chief officers with 1-year contracts with arbitrary renewals, thus creating a climate of fear, uncertainty, and discordance. It was alleged that in May 2019, the first petitioner failed to renew the contracts of all the 23 chief officers and asked them to hand over to their directors. On the charge of gross misconduct, the allegation was that the first petitioner failed to promote public confidence in the integrity of the office of the governor as he was charged before the Anti-Corruption Court. This compromised the social contract and trust bestowed on the governor by the Nairobi residents. The first petitioner was also accused of violating Articles 73 and 75 of the Constitution. It was alleged that there were serious reasons to believe that the governor had committed crimes under national law, especially the Anti-Corruption and Economic Crimes Act. The specific allegations for some of the charges of gross misconduct include the following: the procurement process for the Dandora Stadium. The county government was indicted by the Public Procurement Regulatory Authority for paying Kenya shillings 196 million to the contractor that between 2018 and early 2019, contrary to the law, the office of the County Executive Committee member for Finance and that of Chief Officer Finance were held by the same person by the name Winfred Gadhangu. That after signing the deed of transfer of functions, the governor refused to hand over necessary documents to enable the Kenya Revenue Authority undertake optimal revenue collection, violation of Article 201 of the Constitution on prudent use of financial resources by unilaterally and arbitrarily issuing tax waivers in total disregard to the County Tax Waivers Administration Act, interference with the award of tenders for construction of the Dandora Stadium, leading to loss of funds, massive loss of county funds in 3 years, refusal to hand over crucial information to NMS, hence sabotaging the transfer of functions, using public funds to pay for the first petitioner's daughter to travel to the New York to attend the First Lady's Conference, being barred by the court from accessing his office, thus becoming incapable of performing his functions, admitting that he was intoxicated and not in the right frame of mind when he signed the deed of transfer with NMS. The governor admitted that he was intoxicated by stating that hawa watu wa State House walini confuse na pombe kwanza. By the time I was meeting the president for signing, I was seeing zigzag. Such allegations bring disrepute, ridicule, hatred, and contempt to the office of the president and governor, failing to diligently report to work, yet drawing salary and hefty allowances, use of abusive, embarrassing, inappropriate, and unprintable language, which undermines the office of the governor, publicity and publishing abusive and unbecoming words and language in social media, posts, and numerous rants, thus undermining and demeaning the office of the governor. At the hearing before the Senate, the mover of the motion, Mr. Michael Ogada Okumo, expounded on the above allegations and testified that the first petitioner diverted Kenya shillings 297 million for needy students to other purposes, such as garbage collection and legal fees, thus causing 3,000 bursary beneficiaries to drop out of school. Ogada also accused the first petitioner of failing to assent to the appropriation bill by rejecting it, thus denying the residents of Nairobi City County the much-needed services. He also raised the issue of arbitrary granting tax waivers without involving the county assembly. Also testified that the first petitioner signed the deed of transfer of certain functions between the county government and NMS. He later instructed the acting county secretary not to release relevant documents to facilitate the transfer, thus frustrating delivery of services. Ogada decried the high number of staff at the county, high turnover of staff at the county, and gave the example of the finance docket, which in a span of 40 months had been served by 10 county executive committee members, CECs, and 8 chief officers, COs. Another witness was Janet Mudhoni Oko, a former CEC member for education. She testified that she was unable to perform her functions during her stay in the docket due to persistent, outlandish oral instructions from the first petitioner. She testified that her relationship with the first petitioner was characterized by blackmail, intimidation, and insults. Further, that failure to comply with the first petitioner's unlawful demands, one would meet would be met with threats of non-renewal of her contract. Joyce Kinyanjui testified on the trip to New York and how the expenses were met. The first petitioner denied all those allegations made against him and accused Onogada of having been paid over Kenya shillings 800,000 for a trip to Dubai. Yet he did not travel, contended that he was not an accounting officer in terms of Section 154 of the Public Finance Management Act, and that bursaries and legal services were budgeted items over which he had no control. He added that no specific breaches of the law or constitution had been established against. The first petitioner denied the allegation that he refused to sign the Nairobi City County Appropriation Act 2020 and explained that its implementation had been suspended in Constitutional Petition number 348 of 2020, that he did not sign the budget as it violated values and principles of Article 201 as read with Article 10 of the Constitution. He accused the County Assembly of unilaterally inflating the budget from Kenya shillings 31 billion 434 million to Kenya shillings 37 billion in excess of its mandate. He added that there is no legal framework governing the transfer of funds from the county to NMS, and that this had been confirmed by the Cabinet Secretary, Treasury in writing. The first petitioner also denied the allegations of waiver of taxes and stated that waiver of taxes falls within the ambit of the County Executive Committee and he is only mandated to gazette the committee's decision. He denied the allegation that he intimidated, harassed, or molested any CSC member and maintained that he did not use his office to enrich himself. With regard to the New York trip, he stated that he had no role to play in the said visit and that there was a letter from the head of civil service, Dr. Joseph Kinyo, requesting the Cabinet Secretary for Public Service, Professor Margaret Kobia, to include the names of Ms. Primrose Mwelu Nyamu, County First Lady, and Ms. Saumu Agnes Mbuvi as part of the Kenyan delegation. The first petitioner's first witness, on Sylvia Museya, testified that the impeachment process was procured largely by duress and coercion to serve the interest of individuals, especially the leadership of the County Assembly. He stated that about 67 MCAs who supported the first petitioner were tear-gassed when they met at his office in Upper Hill, Nairobi, and that this explains why they decided to move to Kwale and switch off their phones, which were ringing non-stop. Mr. Emmanuel Kenga also testified in support of the first petitioner's case, as we have already noted elsewhere in this judgment. Mr. Douglas Oma Nyakach, a driver in the firm of Ondieki and Ondieki Advocates, told the Senate that he drove Mr. Ondieki to the County Assembly on 3rd December 2020 at 2 p.m., but they were blocked by policemen from accessing the chamber. Testified that they had carried some documents which they intended to serve on the speaker. Mr. Kelvin Omari Nyabera, advocate in the firm of Mr. Ondieki and Ondieki Advocate, is a personal assistant to Mr. Ondieki, informed the Senate that he took photographs using his mobile phone while they were being blocked from accessing the County Assembly premises. He also processed a video to that effect. The standard of proof in impeachment proceedings was set in the case of Wambora, Court of Appeal number 1 as follows. What standard should be applied in implementing the threshold for removal of a governor? The learned judges of the High Court stated that there is need to maintain a high threshold for removal of the governor and the need to ensure that the law is strictly followed. We do concur with the learned judges and add that the standard of proof is neither beyond reasonable doubt nor on a balance of probability, noting that the threshold for removal of a governor involves gross violation of the Constitution. We hold that the standard of proof required for removal of a governor is above a balance of probability but below reasonable doubt. An impeachment is an important remedy, but one of last resort. It is one to be used where there is an injury to the people. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed came to office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor by the electorate. Our observation finds support in the quotation found in an article titled Memorandum Regarding Standards for Impeachment by David E. Kendall et al., dated 2nd October 1998. I will not read the paragraph. We have carefully analyzed the evidence presented by the parties over the allegations, charges leveled against the first petitioner before the Senate. The issue that this court has to grapple with is whether the charges were substantiated and if there was a nexus between the charges and the first petitioner. The evidence placed before the Senate and the County Assembly was that the first petitioner signed a deed of transfer of some functions of the Nairobi City County Government to Nairobi Metropolitan Services. Subsequently, however, the first petitioner refused to facilitate NMS with relevant documents in order to complete the process, thus hampering the delivery of services to the people of Nairobi City County. One of the grounds in support of the charges was that the first petitioner admitted that he was not in the right frame of mind when he signed the deed of transfer with NMS, as he was intoxicated. The first petitioner did not deny that he signed the deed of transfer, and neither did he deny that he refused to complete the process of transfer. Before the Senate, his defense was that there was no legal framework for transferring money from Nairobi City County to NMS. This does not answer on Ogada's contention that the admission by Sonko that he was intoxicated when he signed the deed of transfer brought disrepute, ridicule, hatred, and contempt to the office of the President and Governor. We find that the conduct of Sonko does not meet the high standards expected of a governor. The deed of transfer was an important document that cannot be seen to have been dealt with in circumstances where the governor was not so sure of. This, in our view, is a violation of the trust bestowed upon the office of governor by the electorate, as it does not portray good governance, accountability, and integrity as expected of a state officer under Article 10 of the Constitution. There is the evidence that there was high turnover of CECs and chief officers. These are county officials that are directly appointed by a governor. Ogada gave the example of the finance docket, which in a span of 40 months had been served by 10 CECs and 8 chief officers. On her part, Ms. Janet Mudhoni Oko testified that she was unable to perform her functions in the said docket due to persistent oral instructions from the governor, and that failure to comply with their lawful demands will be met with threats of non-renewal of a contract. Ogada told the Senate that between 2018 and early 2019, the office of CEC Finance and that of Chief Officer Finance were both held by the same person. He also stated that the governor persistently intimidated, harassed, blackmailed, and molested officers and this was evidenced by the fact that he gave one-year contracts to the CECs and chief officers, thus creating a climate of fear, uncertainty, and discordance. Further, that in May 2019, the first petitioner failed to renew the contracts of all the 23 chief officers and asked them to hand over to their directors. From the proceedings before the Senate, we note that Sonko merely denied intimidating, harassing, or molesting any member of the county executive. We however note that he never denied allegation there was a high turnover of senior staff in his government. Instead, he attempted to divert attention from these serious allegations by accusing the move of the motion on Ogada of having been paid Kenya shillings 800,000 for a trip to Dubai, which he did not make. We say so because Ogada was not the one accused before the County Assembly and the Senate. Sonko was also accused of using abusive, embarrassing, and inappropriate language, and that he published abusive and unbecoming words in the social media. Video clips and extracts from the social media were exhibited at the impeachment hearing. The office of a governor represents the aspirations of the residents. It is a seat of honor and respect. The holder of such an office is expected to carry himself with dignity, humility, integrity, comportment, and respect for others. Where a governor fails to meet those standards, his stay in office is no longer tenable, and the County Assembly and the Senate can invoke the impeachment remedy. This court is not called upon to evaluate every single accusation made against the governor by the mover of the motion. We have in this judgment only highlighted a few of the charges, and we are satisfied that the allegations made were connected to Sonko and were substantiated to the required standard. We therefore cannot fault the County Assembly and the Senate for their decision to impeach Sonko. There was the allegation that the President of the Republic of Kenya was behind the impeachment of Sonko. From the material placed before this court, which is the only material that we are required by law to consider, we do not see any external hand in the impeachment of Sonko. It will be a sad day for this county to imagine that county assemblies and parliament are puppeteers of external forces. These, as per the Constitution, are independent organs that are expected to carry out their duties only in compliance with the Constitution and the law. We therefore find no merit in the claim that the impeachment of Sonko was engineered or instigated for any other reason other than those provided by Article 181 of the Constitution. The final disposition is that from the evidence presented before this court, we come to the irresistible conclusion that the impeachment of Sonko fully complied with the Constitution and the statutory requirements. We therefore find that the two petitions lack merit and are hereby dismissed. With respect to the issue of costs, we find that the appropriate orders is to direct each party to meet on costs. So that is the judgment.
Most obliged, my lord.
Thank you. We have an application to make at this junction.
Just a second, Mr. Nyamu, we will come back to you. Yes, Mr. Nyamu.
Yes, my lord, this particular judgment, my lord, the decision made by this honorable court is appealable, my lord.
Yes.
Under Article 164 of the Constitution, the Court of Appeal has jurisdiction to hear appeals from the High Courts. And for that matter, a party aggrieved by the decision, is dissatisfied with the decision of the High Court,
yes.
ought to be accorded
yes.
not only the opportunity but also an environment for appeal.
Yes.
Judgments, and issue conservatory orders specifically restraining the swearing in of the Deputy Governor under Article 162. At least for as few as 21 days to enable the first petitioner move to the appropriate courts under the Court of Appeal and appropriate. My Lord. My Lord, those conservatory orders from these honorable courts on the basis that it has happened
Stanyamu, you are...
Deputy Governors are sworn into governors only a day after the declaration of vacancy of the office of governor, although my Lord. And my Lord, this has happened. This kind of an application was actually, there's an application that was made in the Wambora case, Wambora 2, my Lord, where his impeachment was declared to be proper by the High Court. And actually your brother, Justice Korti, was in that bench. And on the same day, my Lord, this honorable court issued conservatory orders for 30 days to facilitate and give Honorable Wambora an opportunity to appeal, my Lord. So, my Lord, in that regard, my Lord, we are asking these honorable courts to give us at least 21 days, my Lord, and issue conservatory orders to enable him appeal, as failing to do so would render his intended appeal nugatory and overtaken by events and only to serve academic purposes. As once Kananu assumes the office of governor, then, my Lord, it would be difficult to reverse that position, as she should be deemed to have been elected as governor. And, my Lord, as it is, no prejudice will be suffered. And I know, my Lord and friend, tomorrow and arrest swearing in at 9 or 10 o'clock in the morning. My Lord, I would ask the court to look at the Wambora 2, my Lord, where the High Court issued conservatory orders for the same reasons, my Lord. The first petitioner is a citizen of this country entitled to seek mercies from every court, my Lord, that has jurisdiction to deal with this case. And this court should not deny orders that would be tantamount to frustrating his cause, my Lord. Let the court, as it has decided, let it also not tie his hands, my Lord, by not granting orders that have been sought. And this honorable court has jurisdiction and power to do that, my Lord. I have explained that previously it has done so. It has retreated, deliberated, and gone back on the same day within 30 minutes and issued conservatory orders, my Lord. Justice does not only need to be done, but it ought to be seen to be done, my Lord. And doing justice in the case of the first petitioner would my Lord, until granting those orders, my Lord. No prejudice will be suffered. Nairobi has been operating without the governor, without the first petitioner. And my Lord, nothing will turn on it. Asking us to file a formal application, as I know the respondents would insist, my Lord, would only be a cause to frustrate the cause of justice. My Lord, perhaps any of the advocates for the petitioners should be given an opportunity to also add to whatever issues that are raised, my Lord.
Your Lordship, if I may, my name is Odieki. I'm for the petitioner. Your Lordship, we respect the rule of law and our constitution. The court has decided. But who will suffer any prejudice if you delay the process of swearing in of the new deputy governor for 21 days? Nobody. Can you give us a chance to articulate these issues in the Court of Appeal? And you have power to do so in the interest of justice. We don't want to critique your judgment because you have just delivered it. We want to have a chance to look at it. Then we go to the Court of Appeal, we demonstrate what are the issues. And if you don't issue those conservative orders, the intended appeal will be rendered nugatory. So we are saying we believe in a democracy. Democracy does not believe in chaos. So that your Lordship, if you don't give conservative orders, then it will appear as the court had made up its mind, and the decision cannot be challenged or unpacked in another forum. But that is not the issue here. The issue is that you have made a decision which we respect. We are only requesting for not even 21 days. Give us even 10 days. You have discretion to stay for 10 days. Then we will be able to articulate our issues in the Court of Appeal. Give us a certified copy of the ruling by tomorrow. By next week, we will be in the Court of Appeal. And nobody will suffer any prejudice because, as my learned colleague has indicated, Nairobi City Council has been operating without a governor for the last 1 year. So, Your Lordship, give us a chance to interrogate your findings in the Court of Appeal. That is our prayer.
Thank you, Mr. Ondiek. Okay, I believe the application is has already been explained in line with Mr. Nyamu's comment. Any of the other petitioners, maybe it's only Mr. Okia. There were one or two respondents, I think.
President, my Lord, I would like to, the second petitioner.
Yes, Mr. Mtata.
I associate myself with the submissions that have been made by Mr. Nyamu and supported by Mr. Ondieki. As you realize, a lot of the issues that were canvassed are novel issues. This court has interpreted some provisions of the Constitution for the first time, especially the application of the article on an acting speaker in the National Assembly, what he can do and not do. So most of the decisions the court has made are really being made for the first time. It's only proper that we be afforded an opportunity to mount an appeal in the Court of Appeal. And for it not to be an academic exercise, it's absolutely necessary, as was the case as was the matter in the case of Wambora, to grant the confirmatory orders for 21 days, as prayed by Mr. Nyamu, so that we can give the Court of Appeal an opportunity to look at the matter. And if Wambora's case is anything to go by, you will realize how important that is, because if it had been decided the other way, you would not have had jurisprudence that developed from the Wambora case. That's all, my Lord and my lady. And I submit that this court is seized with jurisdiction to grant orders in terms of execution of its decision. The court is not functioning as official as regards the execution of its decision, so it has got a jurisdiction to grant the prayers being sought. Thank you, my lord and my lady.
My lord, just for clarity, those orders in the Wambora case were granted by Justice London Korti, Justice Mongo, and Justice Odunga on the date of the judgment. My lord.
My lord,
follow the same.
My lord, my lady, my learned friend, I think the interruption of his network made me believe that he had finished. He was still rather submitting. May I add only two issues? Number one, the court has pronounced itself on the intervention that it made in terms of suspending the by-election. Now, that was a constitutional imperative which we held differently. And my lords, my lady, that was the duty and the obligation of the IEBC. And then the court gave a stay of that particular obligation. Now, in similar fashion, we are asking that you grant us a stay, as indeed my learned friends have said, that there was a similar scenario. One of the bench members was participatory in the issuance of a similar order. So the court is not going outside of a practice that it has actually done in exactly similar circumstances. Therefore, your leadership and my lord, you will see that owing to those special circumstances that you had given, that indeed you had stated that indeed the applications warranted. Lastly, Article 48 of the Constitution enshrines the right to access justice. As read with Article 25C of the Constitution, which cannot be abrogated, we believe that your leadership and my lord, that we would be in tandem with giving deference to those rights for the period that we have sought, so that then we can invoke the higher appellate jurisdiction in order, and I emphasize this, in order to give effect to Article 48 to access justice to the petitioners. Thank you.
Yes, Your Excellency. Yes, Your Excellency. Tuko bado hapo.
Okay, maybe we'll allow one or two of the respondents. If you are in agreement, you tell us you're in agreement. We just make our order here. You can see Mr. Usundwa with a gloomy face.
My lord,
you are next. You are the one for the first response.
Yeah, next, my lord. My lord, I'll oppose the application.
Yes.
I pray that they put in a formal application. And most important, my lord and my lady, the name of Anne Kanano has appeared in the proceedings. Anne Kanano is not a party in these proceedings. And more importantly, my lord and my lady, you will note that today you are just the two of you. So even if I was to agree with my learned friend that they could get stay, the stay ought to be granted by the three judges, my lord. So today we are being affected by the issue of quorum, and the law is very clear that the decision must be made by the three judges that were appointed to hear this matter. I believe, my lord, I'll leave to Mr. Shoya and Mr. Kokebe to give further grounds on that. Thank you.
Thank you.
My lord, this is Kokebe for the second response. My lord, I will only want to address 4 issues at once. And I will join in what my last senior Mr. Sulu submitted.
Mr. Kokebe, you are not clear. You are not clear. You are breaking.
Can you hear me?
Yeah, but the line is not clear.
Can't even hear him. We can't even hear what he's saying.
Mohammed, can you mute? Mr. Kokobe, unmute yourself. We have muted everybody so that we see whether it's your system.
Hello, now can you hear me?
Yes, yes.
Thank you very much. Kokobe for the second respondent. My Lord, I'll only be speaking to 4 issues. I support fully the sentiments of my land senior, Mr. Sundwa. My Lord, will insist that the petitioners do make a formal application. My Lord, on my 4 issues. 1, the application by my land friend, Mr. Nyam, my land senior, Mr. Nyam, amounts to an appeal of a decision which is not before this court. Because when you're being asked to stay the swearing in, that was not a prayer in this particular petition. That is a prayer that was in the earlier on petition, which did not see such prayers. So to make such a prayer now will amount to an appeal, this court-sitting appeal. My Lord, it has been told to this court that the justice must be seen to be done. It is to both parties, not only to one party. So both parties, and Nairobians included, have suffered far enough, and it is only good that for the reason that the law abhors a vacuum, that uncertainty should not be allowed to proceed. My Lord, as I yield, you've been told that a court of coordinate jurisdiction was persuaded earlier to grant the order sought. My Lord, it is our argument that that court's finding is not binding on this court. It is but only persuasive. However, we are also alive to the fact that all matters must be determined on their own peculiar facts. Has this court not ventilated these issues? It is a submission that it has. As such, if the petitioner feels aggrieved, as indeed he is, then that is why we have the Court of Appeal. They can seek to have this matter fast-tracked for them to refer their appeal. My Lord, I yield by stating the novelty of an issue does not call in itself for the grant of stay. As such, the arguments by the second petitioner fall on the wing side. My Lord, we will be opposing the application for stay, and should the petitioner be desirous of making such an application, we will insist that let it be a formal application. That will be all, my Lord.
Anybody wants to add his voice? I believe all the issues have been raised.
My Lord, this is Okach.
After Okach, we'll allow...
Just a minute, my Lord.
Yes, Mr. Okach.
Thank you so much, my Lord and my Lady. I'll take under a minute as what I wanted to say has already been canvassed by my 2 colleagues. However, what I would want to go on the court record in opposition to that particular application is the fact that the court has not made any positive orders today. What the court has done is to dismiss the petition. The court has already pronounced itself on that particular issue. So that if there would have been a positive order, then a stay application would have been apt. As of now, if you are to grant these orders, as has been prayed for, it will actually be akin to indicating that the court has not even pronounced itself on these particular issues in the petition. And as such, my request to the court is, as has been requested, let the petitioners file a formal application and we can substantively respond to it. Those authorities are not even before this court, and neither have they been even served upon us to be able to respond. They are only coming from Mr. Nyamu orally from the bar. But more importantly, my lord, as I finish, they have a chance to file the same application for stay under the Court of Appeal rules at the Court of Appeal. The Court of Appeal has an infusion of new judges, so that there is no reason why they cannot even say that they can file this application at the Court of Appeal. Be that as it may, let it go down on record that the 10th respondent opposes this particular application. There is no prejudice that you have been told will be suffered. They have said that the first petitioner has been out of office and they saw nothing wrong. Nairobi continued to run. The globe continued to rotate. Let that be marked as our submissions. Thank you, my lord.
My lord, my lady.
Mr. Nyamodi, you have come back.
I am now back. I would like my learned friend Mr. Nyamu is opposed. Firstly, my lord, the court has made an order which is a dismissal. And I submit that no stay can issue in respect of a dismissal. There is no notice of appeal that has been filed by the party who seeks a stay. And most importantly, my lord, the substantive right that the petitioner claimed in this petition has been adjudicated upon by this court. For those reasons, my lord, my lady, your lordship, the court should not grant the order of stay sought. And if the court is minded to entertain the application for stay, then it is only fair and just that that application be reduced into a formal application, so that all parties have the opportunity to respond to it as the Constitution and the law requires. The application is opposed and the orders sought should not be granted, my lord. I'm most obliged.
Your lordships, if I may weigh in, my name is Ashioya.
Mr. Ashioya, what new thing do you want to add there?
So your lordship, my lady, I just wanted to go on record that on behalf of the third respondent, we vehemently oppose the application by the counsel for the petitioners, and that we fully associate ourselves with the submissions of my colleagues for the respondents.
Okay.
We are most obliged.
My lord, on behalf of ABC, my lord, just to state that we shall, we take no position, my lord, with respect to that application, my lord. We shall leave it to the court and abide by whatever decision this court makes, my lord. We note, my lord, that our client has been vindicated with respect, my lord, to gazetting the date of the by-election. So, my lord, we shall not take any size, my lord, with respect to that application, my lord. We shall leave it to the court.
Okay. Maybe we'll go back to Mr. Nyamu, who will do 1-2 minutes response, Mr. Nyamu, if you'll be the one.
Yes, my lord, as it is, I wish to clarify.
Allow me, because I hadn't had occasion to address my learned friend, allow me to just make one point.
Okay, Mr.
Yes, thank you. Whereas both Mr. Okach and my learned friend Mr. Nyamodi state that we should have a formal application. Our application is made orally, underpinned within statute itself. Order 42 Rule 6 of the Civil Procedure Rules, which apply in such instances, provides that an oral application can be made and ought to be made before that has pronounced itself, which is exactly what we have done. So we're within the province of the law, and as I had indicated, we want to invoke the right to access justice. No one has impeached that right as the underpinning ground upon which we make our application. Mr. Nyamo, thank you.
My Lord, so that this may not be lost, my Lord. Our application is both for stay and power conservatory orders, my Lord, restraining the swearing in of Anne Kanan, which is the implication of the dismissal of this particular petition, my Lord. And it cannot for any matter be ignored. That's a consequence, my Lord. And my Lord, one of the issues that this court ought to deal with, my Lord, and that is buttressed by the case of Peter Gadrau Munya at the Supreme Court, where the Supreme Court in its decision stated that there is need to preserve subject matters of court, my Lord, to enable parties access justice, my Lord. My Lord, as it is, Article 164.3 gives the first petitioner the right to appeal, my Lord. And that particular provision, my Lord, is what would call upon this court to invoke its powers and authority under Article 259 of the Constitution, my Lord, in an endeavor to promote and protect the ends, to promote what is provided under this Constitution, my Lord, to extend that particular authority, my Lord, to ensuring that the first petitioner is afforded an opportunity and ample climate and environment to appeal, my Lord. It is now 6:30. My Lord, friends are asking that we make a formal application. My Lord, this is a defeatist kind of submission, my Lord. As if Anne Kananu is sworn tomorrow, as has happened before. Well, the vacancy of our governor falls today, and by tomorrow, even within 12 hours, the deputy is sworn in. And that has happened in the case of Wajir. It has happened in the case of Kiambu, my Lord. And for that matter, my Lord, this court ought to jealously ensure that it preserves that subject matter and to ensure that it has given the first petitioner an opportunity and environment to pursue his right of appeal, my Lord. My Lord, again, on the question as to whether this bench as constituted can issue those orders, my Lord. My Lord, as it is, we are in an era whereby virtual sittings are possible and allowed, my Lord. In the interest of justice, my Lord, if this honorable court and the two judges, the honorable, my Lord and my lady, if they cannot issue those orders by themselves, my Lord, it would be incumbent upon the court, my Lord, in pursuance of ensuring that access to justice under Article 48 is achieved, to extend their own, to extend lenience, my Lord, and even find the other judge, my Lord, and make that decision. My Lord, it is a case of dire need, my Lord.
I believe you have made your point, Mr.
Okay. Your Lordship, with your kind permission, I just want to raise one point.
My Lord, could you just my Lord. If those compulsory orders were issued, my Lord, and my Lord, when the Honorable Bench, let me finish, my Lord. But the bench in our border case issued those orders, my Lord.
Your Lordship.
Mr. Nyamu. Mr. Nyamu.
Yes, my Lord.
Don't be angry.
I'm not angry, my Lord. I'm only submitting, my Lord. That's my nature.
You know, now we can't hear you. You are our friend. Tell us, we are giving you the opportunity. Mr. Ondiek, be on the standby. I'll come back to you. We have not heard your last part.
Yes, my Lord. I'm asking the court to resist.
Yes.
Anything said by the respondents that is meant to frustrate this cause, my Lord.
Okay.
So, meant to frustrate the first petitioner's rights of appeal, my Lord, as espoused under Article 164(3) of the Constitution, my Lord. This court ought to actually bring home that right, my Lord, ensure that way is that road is made clear with no obstacles, my Lord. One of the obstacles will be if Anne Kananu is sworn tomorrow morning, my Lord.
Mr. Ondiek,
will be there to appeal.
Mr. Ondiek, what do you have to say?
Yes, Your Lordship.